Hey, everybody, it's been a year. Can you believe it?
A year of chalk and gavel.
That's awesome. Our audience is growing. Everything's great. And we'd love to hear from our growing audience. So please take a moment to rate and review Chalk and Gavel on your favorite podcast platform. You can also go to chalkandgavel.com and we have a feedback form you can fill out and let us know what you think about the show.
We'd love to hear from you. We'd also be incredibly grateful if you'd consider supporting us on our Patreon page for just $2 a month. You can help us sustain the show and keep delivering the education law content you've come to expect.
Yeah, and lastly, I just want another shout out for the Education Law Association. The annual conference starts tomorrow in sunny Orlando. We hope to see a lot of our listeners there. And if you are not a member of ELA and you are a sucker for this stuff like we are, it's a great organization. Please consider joining. And next year's conference is in Kansas City. We'd love to see you there.
I'm going to eat so much barbecue.
I know it's going to be amazing.
What does the law say about the appropriate placement for students with disabilities? What happens when parents and the school disagree about a student's IEP? Jamie, are you ready for some more special education acronyms?
Yes, I am. Because today we're going to talk about when, under the IDEA, a PPT's IEP considering a student's FBA and ATE provides FAPE in the LRE.
Okay.
You like that? That's a good one.
That was really good. That was really good. I like that. How many? That was 1, 2, 3, 4, 5, 6, 7 acronyms.
Yeah. We spent a lot of time on that one.
All right. So if you can understand that sentence, then you've got this episode.
Exactly. So we're going to cover today the interesting case of a young student with we'll explain this for you. We're going to cover the interesting case of a young student with disabilities whose parents were not too pleased with the school's determination of how much mainstreaming was appropriate. This case wrestles around in the messy intersection of parent, school, and student rights. Namely, how much say should schools and those who work there with particular expertise have in determining what is an appropriate amount of inclusion in the general ed classroom? How much say should parents have? And how involved should the courts get? Who gets to decide? This is PXREL, Mr. and Mrs. P versus Newington Board of Education, a case about the least restrictive environment provision in the IDEA. That's a really silly case name.
I pity the fool who doesn't understand all of these acronyms.
Yeah, let's just call it P versus Newington.
I like it. Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, Chris, what's this week's bell ringer?
Yeah, so I've got a mini Supreme Court update for you, following up on some of the things we talked about with Mark Walsh in episode 25. So the Supreme Court started their 2024-2025 term on October 7th, and they've already made some decisions to not hear some cases that involve education. So these are two cases that the Supreme Court will not be hearing this term.
Oh.
Yeah, so these are ones that we talked about with Mark that have hit the end of the road. So the first case is Hill or Hilly or Hile or I'm just going to give up on that, Hill versus Michigan, which was a challenge to Michigan's constitutional prohibition on direct or indirect aid to all non-public schools. So remember back, we talked about a group of parents who had students in religious organizations and religious schools who sued the state, arguing that the constitutional provision had an anti-religious purpose and that it discriminated against religious schools in violation of the First Amendment.
Yeah.
And they were basically arguing that this neutral ban, while it might seem neutral on all non-public schools getting funds, was really kind of a intent to kind of run around prohibitions on funding religious schools. And so...
But this didn't fund any non-public schools.
Right. And that was the big deciding factor for the trial court and the Sixth Circuit Court of Appeals when they looked at this, because they found that it did not run afoul of the Constitution because it was generally applicable and didn't discriminate against religion, right? Like this was a law that applied to religion and non-religion in the same way. There wasn't any like specific carve-outs. It didn't burden religious expression. So like all of those things meant that the law was constitutional. And the Supreme Court looked at that and looked at the petition and decided we're not going to touch that right now.
Okay.
And Jamie, you'll be interested to note, no justices wrote separately, either explaining or dissenting from that decision.
Really?
Yeah.
Oh, well, that's nice to have every now and then.
Right. So there's no Justice Alito cheat sheet.
Yeah, right.
This time. Yeah. And so the second case, it's actually, I don't know if this is one that we talked about, but there was this lawsuit, Celine Parents versus Garland, which accused Attorney General Merrick Garland of attempting to silence parental dissent at school board meetings. So you might remember some of the fallout from this, but this was in 2021 during a lot of the like big controversies around COVID restrictions and reopenings.
Right.
And the National School Boards Association sent out this letter to the AG asking for support in dealing with parents that were, being really disruptive of school board meetings, were threatening school board members. And, it was a very fraught political time.
Right.
And so AG Garland sent out a memo that basically instructed the FBI to look into these threats and to work with local leaders to address these concerns. So the letter didn't really say like anything in particular. It just kind of said, look, we're going to look into it. And everyone has rights of free speech, but you don't have rights to threaten local leaders. That's pretty much all the memo said.
Okay.
Some parents weren't really happy about that, though.
Because they want to have the right to threaten whoever they want.
I don't think that was it. I think it was more that they were like, hey, you were trying to silence me
from threatening people.
Well, by like expressing my views in a productive way, I think is how they would think about it.
Oh, okay.
So basically they were saying, you're trying to silence opposing viewpoints.
Okay.
Because we're not really threatening anybody. Like
they didn't think they were threatening anybody.
Yeah, the vast majority of them weren't. But both the district court and the Court of Appeals didn't see it that way, and they sided against the parents. So, there was nothing here that said there was targeting them or that it was actually chilling their speech in any way.
Okay.
So the Supreme Court said, we're not going to take that one up either.
Okay.
So those are two cases that the court will not be taking up. And finally, we got another petition that we're going to have to keep an eye on. The Oklahoma religious charter school decision that we talked about, striking down the first attempt to create a religious charter school.
Yeah.
That has officially been appealed to the Supreme Court.
Hey, we knew that was coming. We thought that was going to come, right?
Oh, yeah. It was very... Yeah.
It was inevitable.
Exactly. Yeah. So we will watch to see what happens with that. I expect Alito's cheat sheet on that one. But, who knows? I thought they would grant the Michigan one, but...
I don't know. With a lot of these religion cases that they've taken on in the last few years, Carson v. Macon and Kennedy and all that stuff, it seems like we've got the cheat sheet.
That's true. Right. Like we kind of know where this is
where
going.
The arguments are going to go.
Right.
Yeah.
And this religious charter school is really kind of the logical
next
conclusion. Conclusion. Yeah. Next step is probably a better way to phrase it than conclusion, because who knows where this is going to end. Right. Like hopefully.
When is this going to end?
Hopefully it's the interplay between the free exercise clause and the establishment clause. And
right.
Having a religious public charter school seems to me to be a pretty clear establishment clause issue. So hopefully this is where, if it gets taken up, which who knows if that's what's going to happen or not, but maybe
the free exercise folks would disagree with you on that.
They would, yeah. Which is where the court has come down in the last, handful of cases over the last decade. So we will see.
I'm really fascinated by whether or not they decide to take this up.
Yeah. Is this something that they want to touch at this moment? Because I think Mark said there will always be another case, right? So like, is this the one that they want to think about?
I'm guessing, I'm just going to guess, it's just a gut feeling. I'm going to say no, they're not going to take it up. I think this is so controversial and...
Well, they've been so risk and controversy adverse. That was sarcasm.
Yeah. No, I gotcha. I just think that I don't think they're going to do it. But
well, we will see.
That's based on nothing. So
right. Yeah. I mean, they only take 60 or 70 cases a year, so the odds are in your favor.
Yeah. No, I know, but I don't know. Again, it's based on nothing because there's often no rhyme or reason. No, I don't want to say no rhyme or reason, but no like publicly available rhyme or reason. Right. We don't always know why they make the decisions to take things up or not take them up. Right.
Right.
So that's the only reason why I say like it's based on nothing. Anyway, that's interesting, Chris. Thank you for that update.
Yeah. So let's dig into some of those acronyms you gave us, Jamie.
All right. That sounds good. Yeah. So we're going to talk about another one of these special education cases. All right. We talked a lot about it with our good friend and special guest, Dr. Janet Decker, back in episode 17. We talked a lot about the IDEA, the Individuals with Disabilities in Education Act. All right. We talked about that with Dr. Decker back in episode 17. So there's a lot of background that we provided there. But we wanted to take some time and cover this. This is, like we said in that episode, the special education issues are often, they're so heavily litigated in the education sphere, right?
Heavily litigated and incredibly complex.
Yeah, and very expensive all around, right?
All around, yeah.
So we wanted to talk about another case that specifically deals with this provision in the IDEA that talks about how important it is to have students with disabilities included in the regular curriculum as much as possible, okay? So the whole idea here is that we should include these students as much as we possibly can to the maximum extent possible with their non-disabled peers.
Exactly.
Right? So that's the idea of this provision in the IDEA. Okay, this is LRE, Least Restrictive Environment. That's what this case is all about, is essentially how do we determine what the least restrictive environment is and essentially who gets to make the decision about how least the least restrictive environment is, right?
Right. Yeah, because the IDEA has a preference for educating students with disabilities to the maximum extent possible with their typically abled peers.
Right.
And so that is typically the gen ed classroom. And so if you want to deviate from that, you have to have a pretty strong justification for moving students to a more restrictive or a environment that is further away from the gen ed classroom. And so when we talk about placement, we talk about kind of this spectrum of potential placements all the way from, the gen ed classroom with full inclusion on one side, all the way to, a separate classroom, a separate school that is solely for students with disabilities so they don't get any kind of exposure or interaction with gen ed peers. So there's this huge spectrum of potential placements. Mm-hmm. The IDEA has a preference for full inclusion, but that's not always the right choice for any given student. So the IDEA includes those personalization options that we've talked about with individualization to make sure that students are in the appropriate placement.
Yeah. And that individualization is generally determined through a student's IEP, which is an individualized education plan or individualized education program, where a group of people, which includes the student and the parent, depending on the age of the student and the disability and all that stuff. But the idea is that a team of people who are invested in that particular student's success come together to assess the student's needs and create a program or a plan that will hopefully maximize that student's ability to achieve or meet with success, right?
Exactly.
And that plan generally includes, general education teacher, a school administrator who often acts as the representative from the school system, special education, other specialists the parent, the student. So the idea is that everybody comes together, they have these discussions, they create this plan that has, measurable goals and, opportunities to assess whether or not those goals are being met, blah, blah, blah. And it's theoretically revisited on a regular basis and
Well,
updated.
not theoretically. The law says it has to be reviewed at least annually.
No. I know what the law says.
Well, yeah, that's a good point. The law might say one thing. Practice might look very different.
Exactly. So, again, the idea is that is reviewed on a regular basis and goals are updated, objectives are updated, all of that.
Placement is updated.
Yeah. Within the IEP, it is generally expressed the degree to which a student is included in the general education curriculum.
Right.
Where do they get pulled out? Where are they sort of included? All of that stuff. I would say it's pretty common to use things like lunch and recess and specials. Like art and PE and whatever as sort of the low-hanging fruit, so to speak, in terms of opportunities for inclusion in the general ed curriculum, right? It's often some of the more academic classes where students might be pulled out or served differently.
Right. And that kind of shows the potential tension here maybe between the FAPE requirement and the LRE requirement. So FAPE, free appropriate public education, LRE, least restrictive environment. So the gen ed classroom might not be the most appropriate place for some students with disabilities who need more support, who need different kinds of support, right?
Right.
And so there's this potential tension with, we want to make sure that students are in the gen ed classroom as much as possible so that they're, experiencing the same education as their gen ed peers. But we also want to make sure that they're getting the supports they need for an appropriate education.
Yes.
And so there's going to be like pull out, you need to do pull out for occupational therapy, for speech therapy, for whatever it might be, for additional help in content.
Yes. Because the idea is if they don't get that, they can't access an appropriate education.
Exactly. Yeah.
Right.
And so that's kind of where this case, or at least where I kind of see this case coming, is kind of at that intersection of like, okay, well, what's an appropriate education, but at what level or what level of inclusion does that entail?
Yeah.
So I always thought like LRE was kind of a weird word because it should be the least restrictive appropriate environment.
Yeah. That's a weird acronym though. LRAE.
Maybe you do it LEAR. Least
appropriate? No.
Okay. That doesn't work.
Let's talk about how all this stuff played out for our young friend P, all right, who is the subject, the student in this case. All right. You ready?
Ready.
So we're back in 2004. Okay. This is sort of long before the Andrew F. case that we talked about in episode 17 that was such a big sort of pivotal case. So it's 2004 and we've got P, who is 8 years old at the time. Okay. I think it's about second grade. We don't know P's name, so it's just listed as P in the documents.
I bet his last name starts with P.
It is possible. Okay, sorry. Potentially. Okay, so P's 8 years old, and P has been diagnosed with Down syndrome, a hearing impairment, and other significant health problems that have required several serious procedures, including surgery to repair a hole in his heart, multiple bowel operations. As a result, he's not toilet trained. So, this child is going to need a lot of supports to access that FAPE.
At 8 years old, like he's gone through a lot. He's got some very significant, needs, it sounds like.
Yeah. So up until 2004, he had been receiving special education services from the Anna Reynolds staff, which included, this is up in Connecticut, by the way, which included a special education teacher, 2 paraprofessionals, a speech pathologist, a physical therapist, and an occupational therapist. So it's
okay. Yeah. So he's getting a lot of support. It sounds
getting a lot of support. Yeah.
Good.
Yeah. And so in the spring of...
And that's the entire episode.
Yeah. So, and scene. So in the spring of 2004, Greg Smith, who was the school district's behavioral consultant, informed P's parents that it was becoming increasingly difficult for P to stay in the regular classroom because of the gap in ability between P and his classmates, and it was causing some concerns with his behavior. So according to the court report, he was starting to show signs of sort of this aggressive behavior, like kicking, grabbing, and hair pulling.
Okay. Yeah, because I think at this point he's in first grade, about to go into second.
Yeah.
Okay.
So P's parents were not happy with that reach out, and mom strongly disagreed with that assessment, and which was basically saying, we're dealing with some stuff and we're probably going to have to start pulling him out of these gen ed classrooms more and more, is essentially what it sounds like that communication was about. And mom was not happy with that. Mom wanted P to stay in the general education classrooms with his typically abled peers as much as possible. That's interesting because the IDEA wants the same thing.
Right. Well, unless, to the maximum extent possible, right? Like if it's not working, then you can do a more restrictive placement. So yeah, Jamie, just something you said.
But that's the thing. That's one of the things that I noticed when reading this case is that it sounds like mom wanted him in there to the maximum extent possible, which is again what the IDEA says. But the disagreement seems to happen
on the degree.
On the degree to, what do we mean by as much as possible?
Right, yeah, and what is possible with appropriate supports and accommodations and all of that, right?
Exactly.
Yeah,
exactly.
So I think we start to see some potential conflict here with the district saying, like, P might need a little bit more support outside of the gen ed classroom.
Yeah.
Mom saying, we want him in the gen ed classroom as much as possible. We start to see some tensions.
Yeah, and those tensions seem to come out in the IEP meetings, okay? So in the spring of 2004, so as we're closing out what we think is P's first grade year, his IEP team meets and they want to discuss plans for the 2004-2005 school year. Okay. In this meeting, P's parents are very clear that they want their son in the regular classroom at least 80% of the time in that upcoming school year. Okay. The district, on the other hand, drafts an IEP providing that P be in the classroom 60% of the day with pull-out services for occupational therapy and speech therapy. And also the IEP didn't have any behavioral goals or measures to deal with this behavior that Greg Smith was talking about. And
interesting.
Yeah, exactly. That's a little interesting. So why would the school district's behavioral consultant say that we've got some behavioral issues coming up here, and then in that spring's IEP meeting, there's nothing put in the IEP that deals with behavior? So that's a little weird.
That is a little odd. I mean, one thing is that these IEPs, you can only put so much in an IEP, and it only makes sense to have so many goals.
Right.
And so maybe they just prioritized other things,
right,
rather than kind of thinking about his behavior, because maybe, his behavior wasn't too disruptive, or, it was something that they felt they could handle.
If that's the case, though, why did the guy feel that it was necessary to send a message about his behavior and say we're going to have to start looking at how included he can be?
Well, and I think that part of that is like maybe they're looking for more information, right? Like, because that's a big thing here too, is like making sure that the decisions that you make are founded in data, are, driven by expert conclusions. Like all of those different things are really important when you're making these kind of determinations. So part of it could also be that the district is marshaling more data. With
respect to getting that data, a functional behavior assessment is often conducted to get that data, and that did not happen at this time.
Right. Which suggests to me that they didn't see the behavior as necessarily like a top priority at this point. Because you're right. Like an FBA, a functional behavior assessment, is typically done when you see these sorts of disruptive or problematic behaviors, because it helps you understand what's causing those behaviors, so you can address the root causes of those behaviors. Right. Through a BIP, a behavior improvement plan. Got to toss another acronym at you.
This is episode 17 all over again. So basically what happens at this point, P's parents not very happy. They don't like this 60% number that the school came up with, that ended up in the IEP. And they asked that a consultant be hired to assess whether P could be successful in the gen ed classroom with appropriate accommodations. So the district agrees to that and hires Dr. Kathleen Whitbread to evaluate P. So in the summer of 2004, like I said, the board retained this consultant, Dr. Kathleen Whitbread, to evaluate P, but P also got a psychological evaluation through the Connecticut Children's Medical Center, which it doesn't say this specifically in the court document, but we kind of assume that that might be at the parent's expense. Like the parent is looking for additional information on their child and they want to go beyond what the school district has provided. So that is our assumption there. That report found that P had the social interaction and communication skills equivalent to those of an average 2-year-old child. The report also found that P communicated primarily through signs, gestures, and single words and exhibited serious problem behaviors, including disruptive behavior, destructiveness to property, and hurting others. And the report concluded that P will need pervasive support, much more than others his age, because of very limited adaptive behaviors and because of problem behaviors. Okay.
Which seems to kind of, I guess, help the school's argument here a little bit that more pull out from the gen ed classroom might be appropriate.
That's what it seems. So Dr. Whitbread completed her evaluation, which was separate from this one that I just talked about, on December 13th, 2004. So it sounds like they hired this consultant in the summer after that spring IEP, and it took the entire first half of the year for her evaluation to be completed. That report appeared to be based on 2 hours of observation at home and 4.5 hours of observation of him in the classroom. Whitbread described P's behavior problems as moderately serious.
Moderately serious?
Yeah, and said that the IEP team had done a commendable job of ensuring that P spends the majority of the day with non-disabled peers. Even though she said that, she also recommended that P's instruction be more closely connected to the general education curriculum. And lastly, Dr. Whitbread also recommended consultation with a teacher of the hearing impaired and a program of literacy instruction. Up until this point, in his second grade year, this is the 04-05 school year, P seems to be doing pretty well under that IEP. His second grade teacher, Miss M, says that P's behavior has improved. He's only been removed 3 times due to behavioral problems that caused or risked physical harm to another person, though that wasn't counting more informal timeouts. Okay?
Right. And that's what we need to know. Like how many
timeouts did he need?
Exactly. Right. Like how included in the gen ed classroom is he?
Yeah.
Right. Because it sounds like he's got some pretty serious supports in the gen ed classroom, like paraprofessionals, other adults in the classroom. Right. So those are the questions I'm thinking about.
Yeah. And so there were co-teachers in that classroom with Miss M, and their job was to integrate P into those lessons. But Miss M said that even though they had those additional supports, P still needed individualized instruction to make sure that he was receiving the best instruction without distraction of being in those gen ed classrooms, right?
So this is the IEP that has him in the gen ed classroom 60% of the time when the parents said, no, we want 80.
Yeah.
But seems to be working fairly well at this point.
Yeah, at least, especially from a behavior standpoint, right?
Yeah.
At least according to his teacher.
But being removed 3 times in first semester, that's not nothing, right? Like that.
Right.
That can be pretty disruptive because you got to imagine that only certain levels of disruption result in a removal. So what does it look like daily in this classroom?
Yeah, I mean, usually that the kinds of disruption that cause somebody to be removed either has to do with these physical altercations, which she said really only occurred 3 times. I don't want to say only occurred because, physical altercations can be...
3 is still a lot.
3 is a lot.
Yeah. But what's the
times,
baseline behavior that isn't rising to that level?
Right. But you could also be removed if you're causing a significant enough disruption to everything else that's going on in the classroom. So you're not only removed if there's physical harm. Like there's other circumstances when somebody can be removed from the classroom. All right. So the IEP team meets again in February of 2005. So we're a little bit more than halfway through the school year. And they meet to discuss Dr. Whitbread's report, because again, that report didn't come out until December. So they meet in February to talk about that report, and the team decides to accept her recommendations for an assistive technology evaluation and literacy instruction.
That's the ATE you mentioned in the introduction.
Assistive technology evaluation, ATE.
Uh-huh.
Yeah. So at this point, Dr. Whitbread does state that P would benefit from additional classroom time, but she concedes that some of the literacy instruction might need to take place outside of the classroom. According to some emails that Dr. Whitbread sent to the special education teacher, it was her opinion that while the parents wanted full inclusion, something closer to 80% would likely be more appropriate given the need for some specialized pullout services. Now, this was something that I found interesting because this email that Dr. Whitbread sent seemed to imply that the parents wanted full inclusion, but earlier in the case report, it said that the previous IEP meeting from the spring of 2004 said the parents were advocating for 80%.
Right. And I think that like the 80% is kind of where the parents seem to have a hard line. Like that seems to be where they keep coming back to.
Yeah.
But I think that's just a recognition that like,
they want a lot. The parents want more than maybe what we think is appropriate.
Right. Yeah. And I think the parents are kind of acknowledging that like, look, some pull-out services are going to be necessary here, like OT, PT, speech, literacy instruction, whatever it might be.
Yeah. So interestingly, at this point in time, February of 2005, the IEP team decides not to finalize any new IEP, and they choose to reconvene in April instead.
Let's schedule another meeting.
Yeah. Yeah. Let's form a committee.
Well, that's what they did. I mean, that's an IEP team in a nutshell.
Yeah. Yeah. We like to form committees. So the IEP team meets again in April of 2005. The special education teacher is there as well. And she says that P's behavior has improved, but that his attention span was limited. P's parents again state their view that P should be in the general education classes at least 80% of the time for the next school year. The IEP team, again, does not make a decision, but it does conclude that P should receive physical therapy in place of the regular physical education class.
Okay, which is another pullout, which is going to count against the percentage of time.
Yeah.
Of mainstream time. Yeah.
So the IEP team meets again in June of 2005.
Uh-huh.
And
another meeting.
At this point, the district was indeed doing an FBA, a functional behavior assessment.
Which is surprising if they're saying the behavior is getting better.
I know.
I guess maybe they're just like, it's getting better, but we still think we can do more. Let's do an FBA.
Yeah. Let's cover all of our bases, and we realize we didn't do one last year, so let's do one now.
Yeah.
So they agreed to hire a behavioral specialist to assess P, and everybody agreed on hiring that behavioral specialist. While everybody agreed on that, there was still the question of placement. So, according to Dr. Whitbread, the team engaged in a, quote, very long, tedious process, unquote, of determining what percentage of the day P will spend in the general education classroom.
It sounds like it, because like this is the third or fourth meeting, right? About this one issue about placement.
Yeah. Yeah.
About percent of time in the gen ed classroom.
Right. So what happened was it essentially went from 60 to 74%.
Okay. Right? That's a significant increase.
It's a jump. Yeah.
It's not quite 80.
No.
But it's not
it's
too
not
far
quite
off.
Nothing.
It's not quite nothing. Exactly.
Right. And as a part of that, participation was going to happen in all regular classes except when he needed to be educated separately to increase his focus or attention. Okay. Or when he needed to be removed from regular classroom due to fatigue or behavior or whatever, right? So the IEP included daily checks of P's hearing aids, adult assistance in activities in the regular classroom, assistive computer programs, extra time and direction on all assignments, the use of picture charts, preferential seating, weekly consultation between the regular and special education teachers. So
Lots of stuff.
Yeah.
Right. And that's kind of what these IEPs do. Like, it's not just the placement. Like, this is all of the accommodations and goals and how they're going to meet those goals. So, like, this is all their services and all of that stuff is in the IEP. So, placement is just a small piece of this puzzle.
Yes. But that small piece, the parents disagreed with. They added a statement in writing to that IEP that they objected to that placement piece.
Oh, right.
Okay. So now
lodge a formal complaint.
Yes.
Well, and then quite literally.
And then, exactly. And then in June of 2005, they file a due process complaint against the district, challenging both the 2004-2005 IEP and the 2005-2006 IEP, primarily on the grounds that P was not sufficiently integrated into the regular classroom. So basically, they're saying that 60% IEP from the 04-05 school year was insufficient, and bumping it up to the 74% in the 05-06 school year
is still not good enough.
So while this due process complaint is going on at the beginning of the 05-06 school year, the IEP meets again in August, right before the 05-06 school year, to agree to hire another behavioral and inclusion consultant. They had hired a hearing impairment consultant. They had hired another consultant to assist with implementing the assistive technology recommendations. So it seems like they've hired like an additional 3 consultants to deal with.
To help out with P's education.
Yeah, to help out with P's education. So before we go into the lawsuit, it's also important to mention the IEP team met again in April of 2006 to discuss one of these new consultants' recommendations. And the IEP developed in that meeting has P in the gen ed classroom setting 80% or more of the school day.
Okay.
Which continued to be the case through the ultimate conclusion of this case in 2008.
All right. So the parents got what they wanted after another round of experts came in to observe P and work with the district.
Yeah. So basically, what we've got is over that 2-year period, P went from 60% inclusion to 80% inclusion. So what about that due process complaint, Chris?
Yeah. Well, it's interesting. Like, the due process complaint is all about kind of the sufficiency of those 2 IEPs and the fact that it didn't have P in the gen ed classroom at least 80% of the time. So, like, the parents got what they wanted outside of the due process complaint, which I think is just really interesting.
Yes.
And it shows something about these cases. Like, these cases are ongoing, but so is the education of the child, right? Like,
exactly.
And that's something that I think is really important to keep in mind, that, like, even while this case is going on, like, the district isn't just sitting on their hands to see what the outcome is. Like, they're still working with the parent to provide P in education.
Right.
So the parents, they objected to the IEPs. And so they file due process. Due process is kind of a shorthand that we use in special education. They're administrative hearings. They go typically before an administrative hearing officer who does, what you might think of as kind of like a mini lawsuit where lawyers are often involved, though they don't have to be. Parents can do it pro se. Districts can also do it pro se. Sometimes you'll see that in places like New York, where they have a lot of special education litigation, but the rules and procedures are much more streamlined than in a traditional lawsuit. So it's a much more, I won't say relaxed, but less rigidly regulated kind of process.
Okay.
So the hearing officer, they collect all this evidence. The district puts on its case. The parents put on their case. The hearing officer hears testimony from P's parents, from all of these educational professionals, from the special ed teacher, the gen ed teacher, Dr. Whitbread, all of these other folks. The hearing officer concludes that the 2004-2005 IEP did not comply with the IDEA.
Oh, interesting.
But the 2005-2006 IEP did.
Okay, so basically they're looking at that 60% versus 74% inclusion, and they're basically saying you did not meet the LRE provision in IDEA under that 60% IEP, but you did under the 74% IEP.
Right. Yeah. So basically that's what they're saying. Yeah. Because the hearing officer looks at that first IEP and says there was too much discretion for local school authorities to remove P from the gen ed classroom. So like that 60% might not have actually even been 60% because it was a lot of discretionary removals.
And it was before a lot of these consultants had been hired, before a lot of the data had been collected.
Exactly.
Right? Yeah.
And that's a huge piece of it is like you didn't have data to support that 60% or less or that discretionary removals were necessary.
Interesting.
And then there's also this issue about behavior, and that IEP didn't do anything to address his behavior because it didn't call for an FBA. It didn't have any behavioral goals or anything like that. So because of those two infirmities, the court says, look, that didn't quite meet the standard of the IDEA. So I'm going to require you, school board, to hire an inclusion consultant with, quote, considerable expertise in placing children with mental retardation in regular classes. Courts, get up on your vocabulary game. That's not how we talk about these kiddos anymore.
Yeah.
Sorry, that is just such a huge pet peeve of mine is that courts don't know how to talk about students with disabilities.
We also speak
Still
Latin.
use, yeah, they
these-
use
in these
antiquated
things.
language
Yeah.
too, right? Yeah, no.
Yeah.
All right. But anyway, so the school district has to hire this specialist, and the school comes back and says like, hey, we actually hired this specialist during this school year with the parents. We all agreed to have this person, and the court's like, oh yeah, that person will work just fine.
Mm-hmm.
So they basically just said that that person could continue to fill that role. And here's an interesting thing. So the parents win on the first IEP, the school wins on the second IEP. The school does not appeal the hearing officer's findings for the first IEP. So the school is just like, all right, hey, you got us.
Okay.
We'll do better.
Okay.
We're not gonna keep fighting that.
Okay.
So while the school decided not to appeal this, the parents did, because they disagreed with the hearing officer's conclusion that the most recent IEP had a sufficient LRE.
Right.
Because the court for that IEP said, the district gave sufficient consideration to P's needs and strengths and abilities, and they had a lot of data to support that this was the right placement.
Okay.
So again, going back to the importance of collecting that data and that information from all these experts and, Dr. Whitbread's report and all of that. So the parents appeal that part of the ruling to the U.S. District Court for the District of Connecticut. So because this is a federal law,
Mhm.
they go straight to federal court.
Right.
And they're appealing essentially two things. First, they don't think that the remedies they got for the first IEP's deficiencies were sufficient. So they said
The inclusion consultant.
basically just requiring them to hire a consultant, which they'd already agreed to hire as part of the IEP process.
Okay.
So they don't think that was enough. And then the second thing is they disagreed that the placement in the 05-06 IEP was appropriate.
Okay.
And so everybody moves for summary judgment, and the trial court says, you know what? This hearing officer got it right.
Oh, okay.
But they also award P partial attorney's fees and costs.
Oh,
That is a very important piece of this puzzle
wow.
because the IDEA has a fee shifting provision where if you are a prevailing parent, you can get your attorney's fees. So if you win a little bit, you get a portion of your attorney's fees. So basically, if they won, let's make arbitrary numbers up. If they won 50% of the case,
Yeah.
then they get 50% of their attorney's fees. And it's not like that mathematical, right? But like it is proportional. Oftentimes courts will do it proportional to the claims you win. So the parents win some, the districts win some. The question of attorney's fees, I think, is really important because it might explain why the parents are continuing to push this.
Okay.
Because they've already kind of spent, they shot their shot, right? And attorneys are not cheap. So if the attorney isn't getting paid through fees from this fee shifting statute, the parents are going to be on the hook potentially for this money. And, we don't know the arrangement that they have with their attorney,
Okay.
but it might explain why we're continuing this lawsuit, even though P is currently at the 80% inclusion that they wanted. All that aside, that just kind of trying to explain potentially why the parents are continuing this litigation, which it seems like things have kind of resolved.
Yeah.
So they appeal the district court's decision to the Second Circuit Court of Appeals. And again, the school doesn't appeal anything, even the award of partial attorney's fees and costs to P. The school is
okay.
like, we're not going to continue this fight.
Yeah. We said what we needed to say. We're cool with how the courts are dealing with this. We're
Right.
just going to sit back and ride the wave.
Right. And continue to defend your appeals.
Exactly.
So, we're appealing those same two questions, whether or not the remedy was sufficient and whether or not the placement was appropriate in the second IEP. And for the question of placement, this is where the LRE mandate comes in from the IDEA. So here is what the IDEA says about the least restrictive environment. It requires that, to the maximum extent appropriate, children with disabilities are educated with children who are not disabled, and special classes, separate schooling, or other removal of children with disabilities from the regular educational environment occurs only when the nature or severity of the disability of a child is such that education in regular classes with the use of appropriate aids and services cannot be achieved satisfactorily.
Oh, all right.
Yeah, so that's what the statute says. And there's some really important things to kind of tease out there. So it says, to the maximum extent appropriate, we're going to educate students in the gen ed classroom. And we can only pull them out of the gen ed classroom when the nature or severity of the disability means that education can't be done satisfactorily in the gen ed classroom.
Yeah, that makes sense.
Yeah, so it creates this preference for inclusion, but it says you can deviate from that if you've got good reason based on the ability to educate that child in the gen ed classroom based on their unique circumstances.
Okay.
And so the Second Circuit has to decide, how do we determine whether or not a child is in the LRE? And so they adopt what is often called the Daniel R.R. approach.
Yeah.
And so this is named after a pretty famous case in special education, which sets out a two-pronged inquiry for determining whether or not a student is in the LRE. Sometimes you'll often hear this called the Oberti approach as well, because Oberti is a subsequent case that kind of clarified or revised the Daniel R.R. standard.
Okay.
So the two-step inquiry requires us to first consider whether the education in the regular classroom with the use of supplemental aids and services can be achieved satisfactorily for a given child.
Okay.
Very similar to the statute, right?
Yep. Mm-hmm.
And if not, we have to ask the question whether the school has mainstreamed the child to the maximum extent appropriate.
Right.
And now, if you're thinking, well, that is just reiterating the statutory language without adding any clarity, I think you're onto something. Yeah. Because it doesn't give us a lot to work with here. It's still pretty vague because it all depends on this idea of satisfactory and, appropriateness, right? And so that's why the court gives us some factors to consider when thinking about these things. So first, the court says these are not all of the factors to think about. These are just some of the factors to think about. We need to think about whether or not the school district has made reasonable efforts to accommodate the child.
Okay.
So that goes into everything that the school was doing to try to figure out how the child can be successful in the gen ed classroom.
And in this case, it seems like it was quite a bit. Like they had, 4 or 5, different consultants. They were, the IEP team was meeting 3 times a year.
Right. Yeah. There's a lot of people involved, a lot of expertise. They met multiple times. They were seriously considering, this wasn't one of those knee-jerk reactions where child was a behavioral issue, so they just wanted him out of the class, right?
Yeah.
Right. That is not this case at all.
Right.
And then the second factor, which kind of leads into that first one, is we look at whether or not the educational benefits available to the child in the gen ed classroom with appropriate supplemental aids and services. Mm-hmm. We look at how that compares to the special ed they can get outside of the gen ed classroom.
Okay.
So basically here we're looking at what's the education inside the gen ed classroom? What's the education outside the general education classroom? And, how do those educational benefits compare? And here, he's got a ton of aids and services in the gen ed classroom, but he needs that more one-on-one support and that more specialized instruction and, pull-out services for, unique things like PT, OT, and all that. So, makes a lot of sense for why the court is kind of, saying, look, the educational benefit of those pull-out classes seems to be really strong.
So it sounds like that, the Court of Appeals seemed to be happy with how everything had gone up until this point.
Yes, the Court of Appeals is very much on the same page as the trial court. And then the last factor that you need to look at to determine whether or not the gen ed classroom is appropriate is whether or not there are possible negative effects of the inclusion of the child with disabilities on the education of other students in the class.
Yes.
And that one is really interesting because it looks at this idea of like whether or not education can be achieved satisfactorily, kind of holistically. So it looks at like, if this child is in the gen ed classroom, what's that educational experience going to look like for him or her and for all of the other students in the class? And so it kind of recognizes that students are often learning from and with each other. And so we need to make sure that this is a sound educational environment for everyone.
For everybody. Yeah.
Yeah. And last but not least, the court here says, some courts will also think about costs of supplemental aids and services. We're not going to think about that because no one argued that costs were a factor here. So we're not going to worry about that.
Yeah, we're just not going to take that up.
Which is interesting because some courts have said costs can be considered. And that's a weird thing under the IDEA because the IDEA says nothing about like, hey, educate students with disabilities unless it costs too much.
Yeah.
Right. That is absolutely not part of the IDEA. So it's always odd to see courts think about costs when they're thinking about LRE.
Yeah.
But so applying those factors here, the court says exactly kind of what we talked about.
Yep.
They
got it all right.
They got it all right. This is an appropriate placement. You went through the process. You listened to the experts. You've got good data. You gave a ton of supplemental aids and services to help him be successful. But even with those, there's educational benefit or a greater educational benefit for pulling him out for these certain things. So, hey, we recognize the parents' advocacy and their dedication, but the school went through the process, justified their decision. We think it's all good.
It sounds like we've got another one of those for your homework.
Dot your I's and cross your T's.
This is do a lot more than nothing. Yeah. Yeah.
Right. Yeah. Like,
this is not a just do something. This is
exactly. This is a listen to the experts, bring in, and like, I think that's something, the district here did a really good job because they engaged in that collaborative process, right? Like they listened to the parents and while they didn't get to the same outcome the parents wanted, they very much went through the process and did what they needed to do to justify their decision.
Yeah.
And that is kind of the most important part. And so, the Second Circuit, the ultimate decision in this case affirms that the trial court got it right. And then on that question of remedy, the court says, look, that remedy was fine. Just because it's what the district was doing anyway doesn't mean it's not a good remedy. It sounds like everyone's fixing it. So we're not going to touch that.
And I think, it's also important to mention that like these are hard issues. It's hard for schools to meet the needs of so many differently abled students. And when I say differently abled, I'm not talking about people, who qualify for services versus people who don't qualify for services. I'm just saying there are so many millions of kids in our system with such a wide variety of needs, and we've got a system that is supposed to try to meet all of those needs. And that is so hard to do.
It's so hard to do.
We are required to do that.
We're required to do that. And then the way in which you are required to do that is also very prescriptive, right?
Right.
And so like the IDEA sends out some very specific requirements for how you do that.
Yeah. And my point is, while that is so incredibly hard to do, we can't also discount how important it is to do that and how important it is for the child and the parents of that child. Listen, advocate for your kids.
Right. And the parents did that and they did a great job of it because they ultimately got where they wanted to go too, right?
It took a couple of years, maybe that, some folks in this case said, I thought that was going to take a couple of months and not a couple of years or whatever. But, they ultimately got what they were advocating for. But the point is, especially if you've got a child with disabilities, it is so critical that you advocate for them. But, also understand that it's, the schools and the districts are also in a very tough position. That doesn't mean that those children do not deserve everything that they deserve, right?
Right.
This is just another one of those cases that I think is illustrative of how emotionally charged and how complex and, these are people's lives. These are kids'
and
lives.
People's kids, right? Like that's the most important thing.
Yeah. Exactly.
Yeah, I think that all just kind of emphasizes the collaborative nature of the IDEA process. And like when it works well, it works really well because everyone comes to the table. They have open and honest conversations. And, you know, sometimes those break down and people come to different agreements, but like it doesn't undermine the importance of those kind of relationships and that communication. Because think about this, like P's parents and the school have to work together for another decade after this lawsuit, right? Like
totally.
So these relationships are absolutely so important.
Relationships, people.
That's the takeaway, right?
Yeah.
Do the maximum. Don't do nothing. Relationships. You got it. And bring your receipts.
That's it. Beautiful. All right. What's your homework? What's our homework? I don't know.
Do we have homework? We can't give ourselves homework.
No. Well, what's everybody else's homework, Chris?
Your homework is to, I think, do all the things we just said, right? Like that was a pretty good list of nuggets there. But you can find Chalk and Gavel at chalkandgavel.com, wherever you get your podcasts. If you would go to chalkandgavel.com, we've got a survey up there that you could fill out to kind of give feedback for the show. We would love to hear from you and just kind of continue to grow and develop the show. You can find us on social media at Chalk and Gavel. We'd love to continue the conversation and continue to nerd out about all this education law stuff.
Absolutely. Cool. All right. Well, there's another one of our special education cases. And,
hopefully we explained all of those acronyms.
Yeah, that's right. Okay. Well, that was fun. We'll see you again in 2 weeks, everybody.